in today's class, we'll be talking about the Basic Structure Doctrine. Now, whenever we talk about amending the constitution, this terminology is extensively used. Now, this doctrine as per se has not, is not a part of the constitution from the very beginning. There is a proper story or a history to the development of this doctrine. So in today's class, what we'll try to do is map out the trajectory through which this doctrine has come into existence. Now, if we look at it, we have to first start with what is the problem that the doctrine is trying to solve. And this brings us to the basic question, why is there a need to amend the constitution? Now, we have dealt with this question in the previous lecture. But again, let's just take a quick recap to why is there a need. If you look at it, the constitution was drafted over a period of more than 2 years, and there was a very long process of deliberation by the Constituent Assembly to draft the constitution. However, in the constitution itself, it is clearly mentioned that with the changing times, there might arise a circumstance when the constitution would need to be amended, that is to be changed or altered in some form. The reason is that the constitution was written at a particular juncture of time. That is, the social and economic conditions of that time were very prominent in how the constitution was drafted. Today, that same socio-economic circumstances have changed. And the issues or the problems today might need a solution that would need the constitution to be amended. So we do have amendments that have brought in the reservation laws or has made compulsory education a right. So there are these issues and solutions that have made or that have let the constitution be amended due to the changing socio-economic realities. Now, we all have studied what is the procedure for amendment. Now, if you look at it, there is a conflict in the constitution itself, and that conflict lies in Article 13 and Article 368. So let's go to first Article 13. Now, Article 13 gives us the means for judicial review. Judicial review as in the power of the court. We have already studied about this when we talked about judiciary, how the judiciary can step in to look into the validity of the law, right? So Article 13 further states that it enjoins a duty on the Indian state to respect and implement the fundamental right, and at the same time it confers a power on the courts to declare a law or an act void if it infringes the fundamental rights. In other words, Article 13 says that the judiciary has the power to declare a law or an act null and void. That is, it can negate it, it can stop that law if that law infringes or if it violates any fundamental rights. In other words, the part of fundamental rights cannot be amended by the parliament. Okay, so this article gives the power to the judiciary to limit the power of the parliament in amending the fundamental rights of the constitution. Okay, I hope this part is very clear. So let me put it in other words also. The judiciary, according to this Article 13, has more power than the legislature. Why? Because it can restrict the legislature from amending the fundamental rights that is there in the constitution. Okay? Now, in the same document, that is the constitution, Article 368 states that the power of the parliament to amend the constitution and procedure, right? It is giving the power to the parliament to amend it, okay? And it says that parliament may in exercise of its constituent power amend by way of addition, variation, or repeal any provision, any of this constitution in accordance with the procedure. So today we will not talk about the procedure. The idea is to focus on the words that talk about the power of the parliament right now. So the power of the parliament is that it can amend any provision of this constitution. So Article 368 gives a completely opposite scenario, wherein the legislation or the parliament has been given power to amend the constitution. So therefore, according to this law, according to this article, the judiciary cannot stop the parliament from amending the fundamental rights. Now this is where the confusion arises. This is the dynamic opposite issues that have been debated over and over again through various cases and constitutional amendment acts. So I hope you've understood the problem that is there, right, between Article 13 and Article 368. So now let's come to the first Constitutional Act. Now the first Constitutional Act was passed in 1951, and the Constitutional Act was proposed by the then Prime Minister Jawaharlal Nehru. Now in this Amendment Act, there were several changes that were proposed and accepted, out of which for today's discussion 2 articles are important. Article 31A and Article 31B. Now apart from that, this first Constitutional Amendment Act also brought out some restrictions on the freedom of speech and expression. Now Article 31A and 31B brought in restrictions to the fundamental right of property. So at this point of time, we had seven fundamental rights. Today we have 6 fundamental rights. And at that point of time, the right to property was one of the fundamental rights. Now Article 31A and 31B tried to bring in restrictions on this fundamental right to property. The articles basically indicated that the government could acquire or possess lands that were there with private entities for the use or for the benefit of the nation, and it would be the government that would decide on the compensation that would be given in lieu of that piece of land. Now all of this was done in order to usher in land reforms. Okay. So at this point of time, again in historical context, there was a lot of social inequality, and the country's economy was not growing. There was unemployment. The partition trauma was pretty, was affecting the society, and in order to usher in more economic growth, the government was trying to take in more and more private land in order to bring in development. Okay, and because of this, these 2 articles was brought in through the first Constitutional Amendment Act. Now again, what happened was Articles 31A, 31B talked about government acquiring private property, right? Also, these articles, especially Article 31B, talked about putting this into the 9th schedule. Now, 9th schedule is important because all the laws and acts that are there in 9th schedule is beyond court's review, right? The court cannot review that law or that act. So what happened was that the Amendment Act put these articles in the 9th schedule. Soon after, which basically indicated that certain restrictions were coming in to your fundamental rights. Now individuals started moving in. So now let's come to the Shankriprasad and Union versus Union of India case. Now that we have understood what happened with the first Constitutional Amendment Act, there were several individuals who started filing cases in which they said that their fundamental right, that is right to property, was being curtailed. And several such cases started coming to the Supreme Court. Now, one of the major cases was the Shankriprasad versus Union of India case, wherein the judgment said that Article 368 conferred the right to the Parliament to make amendments to the Constitution, okay, which also included the fundamental rights. In other words, the Parliament had the right to amend the fundamental rights. Now, as per Article 13, this applied only to ordinary laws. That is, the judicial review that we talked about was applicable only on ordinary laws and not on constitutional amendment acts. So, in other words, the Parliament had complete authority to amend the fundamental right. So, this was the Shankriprasad versus Union of India case. Soon after, there was another case, that is the Sajjan Singh and the state of Rajasthan. And even in this, Article 368 was given supremacy. That is, the Parliament had the power to make amendments to the fundamental rights. Now, Sajjan Singh and state of Rajasthan was a 5-bench judgment. And this was then sent for a re-evaluation, was sent above to a 11-bench wherein the Golaknath versus state of Punjab also looked into this question, right? Now, this was a 11-bench judiciary, okay? So, there were 11 judges up here. And in this, what happened was the same question, that is, does the Parliament have the authority to amend the fundamental rights, was discussed. And Golaknath case overturned the previous judgments by saying that no, the Parliament did not have the right to curtail or amend the fundamental rights because of Article 13, right? And this is where it overturned the previous 2 judgments that were given. Now, Golaknath case became important because it created a tussle of power between the judiciary and the legislation, that is the Parliament. So, now what the judiciary has maintained is that the Constitutional Amendment Acts were under the judicial review. Judiciary can stop the Parliament from making any amendments to the fundamental rights. Okay? So, Golaknath case became a very important case at this point of time. Now, this was obviously not accepted by the Parliament, and this is a gross stepping in of power of the legislation, and that is the reason why soon afterwards the 24th Constitutional Amendment Act was passed. And in the 24th Constitutional Act, Clause 4 was added to Article 13 and Clause 3 was added to Article 368. In Article 13, the Clause 4 stated that the review was only limited to other aspects except Constitutional Amendment Acts. That is, this Constitutional Amendment Act completely overturned the Golaknath judgment. And it said that the Parliament had the authority to amend the fundamental rights. Clause 4 maintained that it was only limited to other laws, not the Constitutional Amendment Act. And Clause 3 of Article 368 said that in the procedure to amend the Constitution, when the bill reaches the President, he or she is bound to approve, Earlier, this wasn't the case. The president had the authority to send it back for review or wait for giving his or her approval. But now, as per this clause, the president was bound to approve. So the parliament took back the power from the judiciary and overturned the Golaknath case in the 24th Constitutional Amendment Act. Following the 24th, the 25th Constitutional Amendment Act, as well as the 26th and the 29th. So let me write the numbers now. 25th, 26th and the 29th Amendment Acts all curtailed the fundamental rights. 29th had land reforms which curtailed the right to property. 26th was the abolishment of privy purse. And the 25th Amendment also brought in restrictions to fundamental rights. Because of this, the parliament or the legislation kind of took the power balance towards itself, and this became a major concern for the judiciary. Soon afterwards, we have the main prominent case in this matter, the Kesavananda Bharati versus State of Kerala case. Now, this is also known as the fundamental rights case. Now, if you look at this case, it all started with the Land Reforms Act that the Kerala government had passed. And in the state of Kasaragod, it's an area in Kerala, the mutt, the Ednir mutt, had a lot of private property. Now, this mutt was, the leader of this mutt was Kesavananda Bharati. Now, the mutt had a lot of private property which the state of Kerala possessed based on this Land Reforms Act. And because of this, the Kesavananda Bharati took this case to the Supreme Court and challenged not only the Constitutional Amendment Act of the Constitutional Amendment Act of 24, 25, 26 and 29, but it also challenged the idea that the Parliament can amend the fundamental right. Now, for the first time, the Supreme Court brought in, compared the fundamental rights and the same kind of rights that were there in more than 70 plus countries. It compared constitutions. It is one of the longest running case that went on. And finally, the judgment, which was again a very lengthy judgment, gave a very balanced approach to the problem between Article 13 and Article 368. Now, what the approach was is that in the Constitution, there is a basic structure. Now, this basic structure is, the foundation of the Constitution and therefore the foundation of India. For example, like the democratic nature of the nation, the federal character of the nation, the secular nature of the nation, and so on. Now, these are these fundamental pillars of the Constitution as well as the nation. Now, what the judgment said was that the Parliament had the right to amend any part of the Constitution, including fundamental rights, as long as the basic structure of the Constitution remains the same. Now, let me give an example here. Now, imagine you have a building and there are 4 basic pillars, okay, foundational pillars that is holding the building. And now, we give the property is given to an architect and is said that you can break this house, remake it as per your understanding of what suits the need of the client, as long as the basic pillars remain, okay. So now, earlier the house was, let's say, a high rise with 4 basic pillars. Now the architect removes one of the walls, extends it, adds more pillars and all of that. but the four basic pillars that was holding that property remains, and that is what basic structure meant. So this case judgment gave a very balanced approach between Article 13 and Article 368. It said that as long as the basic structure of the constitution remains, the parliament had the authority to amend any part of the constitution, including fundamental rights. Okay? So thereon, there were several further cases that came in, like the Minerva Mills case. The Minerva Mills case in 1980, in which the Supreme Court again and again reiterated the importance of the doctrine of basic structure. And this laid to rest the tension or the difference of opinion that arose from Article 13 and Article 368. From then on, the doctrine of basic structure became the solution to the problems that arose between the judiciary and the legislation. It laid to rest the tensions emerging from these two organs of the government. Okay, I hope you have understood what is the doctrine of basic structure. So now let's do a quick recap of what we studied today. So we first understood why is there a need to amend the constitution. We then took a look at the first Constitutional Amendment Act, followed by the two cases, that is the Shankriprasad case and the Sajjan Singh case. And we talked about how these two cases gave importance to Article 368, wherein the Parliament can amend any part of the Constitution. Thereafter came the Golaknath case, wherein it said, the judgment said that the Parliament did not have the authority to amend the fundamental rights. There were limitations on it. And Article 13 became supreme, right? And Article 13 meant the judiciary can negate any law that was infringing or in violation of the fundamental rights. Soon after, we have constitutional amendments of Article 24, 25, 26 and 29, wherein the Parliament took back the power from the judiciary by stating that the legislation had the authority to make amendments. Finally, in the Kesavananda Bharati case, a balanced approach emerges wherein the doctrine of basic structure is given, and in this what it means is that the Parliament can amend any part of the constitution as long as the basic structure of the basic ideas or the principles of the constitution remains. These ideas could be the federal character of the nation, the supremacy of the constitution, so on and so forth, right? And these ideas are fluid in nature. It is not important that what the list was given is exhaustive. It is not. As and when circumstances demand, these ideas or the basic structures can increase and decrease. Okay, and this is all about the basic structural doctrine of the Indian Constitution. With this, we come to an end to today's class. Thank you.